On Law Weekly today, two senior legal practitioners review the judicial sector in the year 2017 and give suggestions for reforms this new year. We have the views of Mr. Wahab Shittu, an academic and a foremost prosecutor for the Economic and Financial Crimes Commission, EFCC. We also have the views of the former chairman of the Nigerian Bar Association section on business law, Mr. George Etomi, who gives us a business/commercial perspective, plus the opportunities for young lawyers in the year 2018. That's our lineup. Hello and welcome to the program. I'm Shola Shoyeli. We begin straight away with the views of Mr. Shittu. I started by asking him to assess how the judiciary fared in 2017. Let's start with an assessment of the judiciary. How would you say that sector fared in the year 2017?
Well, the judiciary of any country is assessed by factors such as autonomy, independence, fairness, respect for the rule of law, and above all, compliance with the elements of justice. So, to the extent, if you use all these parameters as a yardstick, we will say the year 2017 is remarkable in that we had coming on board a Chief Justice of the Federation that is determined to constructively engage all the stakeholders in the administration of justice. And happily, his efforts is also being complemented by a proactive and visionary MBA led by the President of the Nigerian Bar Association. So you find a robust, relationship between the bench and the bar to be able to address all the fundamental issues confronting judiciary. For any assessment of the judiciary in any given year is work in progress. You constantly have to retool and refine and reform the process in order to be able to ensure speedy dispensation of justice, to avoid minimal delay in the dispensation of justice, and above all, to restore public confidence. And the one thing that is remarkable about the outgoing year is the self-realization by the judiciary that it is necessary for it to embark on self-cleansing measures in order to weed out certain very few bad eggs that is allegedly trying to give a negative image to the judiciary. And you can see a Chief Justice of the Federation who is determined to entrench his name in letters of gold. You saw the commitment to fight corruption even from within, resulting in the attempts to strengthen the activity of NJC, and then even attempts to put in place a judiciary monitoring committee to be able to monitor the activities of judges, the activities of lawyers, and those who are generally involved in the administration of justice. So you see a judiciary that is determined, a judiciary that is not shying away from negative perception in the public place about increasing loss of confidence, a judiciary that is aware that people are increasingly losing confidence in the institution, and there is a need to take urgent proactive steps. And that is salutary. It is not a judiciary that is deceiving itself. It is a judiciary that is aware that there are problems, and these problems must be addressed by all the stakeholders. And when we say all the stakeholders, we mean both the bench and the bar, and those who are connected one way or the other with the administration of justice. And this has thrown up a lot of issues. The first issue is the issue of corruption. You can see that in the outgoing year, when allegations were made against certain categories of judicial officers, NJC promptly responded by saying that the affected judicial officers should stop sitting until issues surrounding them are resolved. And you can see a judiciary that is saying, oh, we are ready to submit our, those who are accused of any offense for trial. And you see some of these, highly placed, judicial officers, willingly submitting themselves for trial in deference to the requirements of the rule of law. And then the setting up of the Judicial Monitoring Committee and the fact that they have swung into action is a pointer that the judiciary is aware that there are problems that they are really ready.
I know you say the judiciary is self-cleansing, but some people would argue that the judiciary sought to take with the right hand what he gave with the left hand, especially when you consider the Court of Appeal judgment, which says that 7 judges can be prosecuted, except if they've gone first through the discipline of the NJC.
You have to be able to make a distinction between administrative measures designed to sanitize the judiciary and judicial determination of issues. It's part of the autonomy and the independence of the judiciary for it to determine issues raised before it. And you are not to say such issues have been determined in manner not in conformity with your expectations. If it's not in conformity with your expectations, there are avenues for appeals. As the fact that the Court of Appeal has pronounced that certain steps need to be taken before judicial officers are arraigned does not derogate from judicial independence and judicial immunity. In fact, it strengthens those mechanisms because we also those who are aggrieved by that decision also have an opportunity of testing it further, all in the bid to sanitize our judiciary and enhance the quality of our jurisprudence. So what is going on, even with the pronouncement, is an attempt to strengthen judicial mechanism. Outside that, we also look at the issue of obedience to court orders. I think in several fora, the judiciary came out clearly to say that, we will no longer tolerate disobedience of court order, even from the executive. And I want to make reference to the last visit of the NBA leadership to Mr. President, where some of these issues were raised. Because in an ideal democracy, there should not be anything like disobedience of court orders. Nobody is above the law. Once a judicial pronouncement is made, the executive and all those concerned must respect it. So it is not, it should not, if court orders are disobeyed, that in itself is corruption. And I think no decent democracy will allow that. And I think the bench and the bar are in agreement about this. And the executives are also being sensitized that they need to respect court orders if we are to strengthen our democratic tradition. The other issue is the element of delay. When justice delayed, they say justice is denied, and we have cases, cases of such even in the previous year. But it is not that those cases have not arisen. But the significant point to be made is that the bench, led by the Chief Justice of the Federation, and all other stakeholders are aware of this problem and the negative impact it is making in the public space. And there are measures being taken. The Chief Justice of the Federation has given directive that all the judicial heads must, constitute special courts to handle specific cases in order to accelerate the pace of proceedings and restore public confidence. This is salutary. In the history of this country, it is unprecedented when you see, clear-cut, pronouncement being made by the Chief Justice of the Federation, to address some of the problems that is occasioning, negative perception in the public space. So the issue of the delay, which is a serious problem, is being addressed in the previous year, and there are likely to be more improvements around this area in the coming year.